Hello, everyone, and welcome to this conversation on demurrage, detention, and managing port operations with the Federal Maritime Commissioner, Carl Bentzel. I would like to thank Ocean Insights, a Project 44 company, for making this conversation possible, and also to Charlie Pesti for organizing this. Just a background about our honorable guest today. Commissioner Bentzel was nominated to the Federal Maritime Commission by President Trump on the 12th of June 2019, and he took office on the 9th of December 2019. And Commissioner Bentzel comes with a vast experience in regulatory and legislative issues, having served in both the public and private sectors. Most recently, he was a senior Democratic counsel of the Senate Committee on Commerce, Science, and Transportation. And he took on this role after having spent 4 years on the House Committee on Merchant Marine and Fisheries Committee as counsel for maritime policy. And whilst in the Senate committee, Commissioner Bentzel was instrumental in drafting the Maritime Security Act of 1996 and the Ocean Shipping Reform Act of 1998. And after 9/11, he was also involved in drafting the requirements mandated for maritime security as part of Maritime Transportation Security Act of 2002. Commissioner Bentzel is also the recipient of the Coast Guard's Medal for Meritorious Public Service and the Maritime Security Council's Man of the Year Award. And he's also the author of the chapter on port security within McGraw-Hill's Handbook on Homeland Security. So without any further delay, I would like to welcome Commissioner Bentzel to this discussion. Good afternoon, Commissioner, and welcome to this conversation on demurrage, detention, and managing port operations.
Hariesh, it's nice to see you again. We had a little time to meet in advance of our meeting, so looking forward to our discussion.
Great. Commissioner, can you give us a brief about the Federal Maritime Commission in terms of its role and functions within the shipping industry, and also a brief on this important topic of demurrage and detention and what is its status in terms of global trade, because there's a lot of discussions and noise, if you may, about demurrage and detention.
Sure, Hariesh, I'd be happy to. The Federal Maritime Commission has actually been around since 1916 in the federal government, and it's been through a number of iterations, but our current iteration, the commission has been there since 1961 as an independent regulatory agency. We have 5 commissioners. We're all nominated by the President of the United States and confirmed by the U.S. Senate, so you have to go through a hearing process. And we all have sort of like a judge, a 5-year term, and the commission makeup is dictated in terms of the commissioners by the president's party. So right now, President Biden, who's a Democrat, has the authority to add an additional Democrat to our party, and actually yesterday announced his intent to appoint my colleague, Dan Maffei, to be our new chairman, as the Democrats are taking control of the commission. And as I say control of the commission, it really is a nonpartisan commission comprised of experts that have been working in the shipping industry for a number of years. And so we really get along pretty well, although you see in the news occasionally all of these areas of politics in the United States where you have lots of fighting and infighting and backstabbing. We really don't have that, and that's a very cordial atmosphere. We have an authorization for 128 time personnel with locations throughout the United States. Most of us are in Washington, D.C. Our mission is to establish a competitive, reliable international ocean transportation supply system that supports our economy and protects the public from unfair shipping practices. We've worked closely with foreign shipping lines and our domestic ports and U.S. carriers and shippers. So it's a interesting mix of parties that present themselves at our agency. And I think we try to regulate in a way that is consistent with other regulatory agencies to avoid conflict. Our key functions are we regulate oceanborne transportation in the foreign commerce, and that's liner shipping. That is not oil tankers and bulk shipping. And we oversee a limited antitrust regime. That is, carriers and marine terminal operators are entitled to come in to the FMC and present agreements for cooperative work, and we'll review those agreements. If we feel that they're not anti-competitive, we can let them go into effect. These sort of agreements often are agreements on how to reduce emissions, for instance, or combine the pooling of intermodal chassis, or they could be space sharing arrangements with large container companies. We're authorized to function as a judiciary body on certain maritime complaints, resolve disputes, and we also have trade authorities to review the action of foreign national policies to ensure that they don't create unfair shipping in the foreign commerce of the United States. Again, we have field offices in New York, South Florida, New Orleans, Houston, Southern California, and Seattle, our large port destinations. We have representatives in these areas that are part of the shipping public. They're there located to serve as ombudsmen for complaints, to work, to educate the public, to represent the agency in the field, and help resolve complaints that we receive. As you mentioned, the focus of this is demurrage and detention policies in the United States. And I really like to focus on not the explicit issues related to demurrage and detention and the policies, but because you have to look at the context of demurrage and detention and the reality of the marketplace. And that is implementation of penalties and fines, a function really of whether or not the operational management of our port and intermodal shipping industry is working. You don't have these sort of charges absent usual issues related to trade fluctuation, the Suez Canal, issues related to what I would call force majeure, where conditions in the industry are creating issues related to normal operational requirements. Detention and demurrage, D&D is what we call it in short, are penalties and fines for keeping equipment out of the port for excessive periods of time or not picking up your cargo. So essentially, these are policies intended to create an incentive for the movement of cargo through the chain. We have statutory and regulatory requirements on the Commission's laws, and our laws essentially are we protect the public from unjust and unreasonable practices and cargo handling, and that includes the implementation of detention and demurrage penalties. The latest round of D&D requirements that essentially culminated in a FMC issuance of guidance on how these penalties should be assessed took place in the aftermath of a force majeure event, and that was the aftermath of the Hanjin bankruptcy. The FMC was petitioned by a coalition of shippers, and it led into essentially an investigation by the FMC about what was happening in the aftermath of the disruption of trade. We received comments from the public in response to this investigation, which was Fact Finding 29, and then finally published a potential regulation for the public to consider. And that took form ultimately in guidance that we provided the shipping public on how you should implement penalties and fines, demurrage and detention practices. The general principle that the agency decided to use in evaluating whether detention and demurrage charges, D&D charges, were fair was whether or not they were intended to create fluidity in the movement of cargo, incentives that would help move cargo, or whether they were being penalized, the importers, the exporters, the truckers, based on conditions outside of the control of the beneficial cargo owners or shippers. And so we attempted to set up general standards of how the industry should conduct itself with the implementation of these penalties. We focus on providing transparency in terms of notice, of availability of cargo, of practices that should be engaged in billing, empty return of containers, and issues related to the intermodal chain in the United States, our supply chain. And I've visited many ports throughout the world, and I would say that the situation that we have in the United States is incredibly complex from an intermodal perspective, where we have many different parties involved. For instance, at the port of LA Long Beach, we have large container ships coming in. We have marine terminal operators largely separate from the carriers themselves. We have owners of chassis, intermodal chassis, that are separate from the marine terminal operators, who are separate from the carriers. We have drayage trucking companies. We have container lessor companies that are providing equipment. And then further, after it gets to the port, we usually take these cargoes either into large intermodal rail operations, or sometimes warehousing, where it's offloaded onto domestic trucking. So the complexity of our system has resulted in a need to really look closely at how these penalties are constructed, but even further, how our major port complex operates. And that's why we wanted to make sure, and the title of this presentation, that there was focus on those operational requirements. We had some challenges along the way in trying to assign liabilities and responsibilities for the parties. I would say detention and demurrage serve both the interests of carriers who sometimes are blamed for charging these penalties, and also for shippers who need to keep the market fluid, who need to pick up their cargo, who need to get equipment back to the terminals so that the system can continue to work. So it was pretty clear when you can see a situation where a shipper, for instance, cannot bring back intermodal chassis to a terminal because the terminal's closed. They shouldn't be charged for that. But it gets more complex when you look at issues such as who can charge penalties during periods of government inspection. So that's where we are on the general issues of detention and demurrage. And I think probably more importantly right now is the issues that we're facing internationally, not just in the United States, in the supply chain disruption caused largely by COVID-19, and then subsequently impacted by factors that are leading to maybe potentially a market shift in favor of more e-commerce, in favor of PPE, in favor of stay-at-home. I like to say stay-at-home mentality, where we're doing more from our home and less in these large businesses and communities and cities. During COVID-19, U.S. ports saw 20 to 30% reductions in the amount of intermodal traffic through our ports. By early summer, a 20 or 30% increase in the volumes of cargo. And so we found that we were short on chassis. So even though cargo was getting to the ports, we weren't able to get them through the terminals and into the intermodal system. And then it started to build there, where we started to receive a buildup of cargo ships. Right now, we have 26 large container ships outside the LA Long Beach port complex. I believe 20 vessels offshore and off of the coast of Oakland. We have a lot of additional challenges that have been created as we went through this COVID recovery, I guess, a halting COVID recovery that had created challenges throughout the chain. And so I was talking to someone today on the West Coast, a marine terminal operator, who indicated now the ability to get longshoremen back to work based on getting vaccinations. The backlog of cargo was sort of dissipating on the terminal side, but was emerging at the railroad terminals, where a lot of our interior cargoes were being held up for lack of railroad equipment. So it seems as if as we've gone through one challenge and identified that challenge and attempted to overcome that challenge, other challenges have emerged with this new, and I would say potentially permanent market reality. So against that backdrop, detention and demurrage is in place, and it's intended to facilitate the flow of freight. But we're getting a lot of claims, frankly, in the United States that it's being used as a penalty, where shippers or BCOs or truckers are being forced to pay claims for D&D, even though they couldn't impact what had actually occurred, and it was under the control of a terminal or a carrier. We have, in order to address the challenges that we've had since COVID-19, the FMC, under the leadership of Commissioner Dye, has established another fact-finding investigation, and that fact-finding is ongoing. And we're looking at three issues and evaluating whether we can do anything to help move the process and the delivery of cargo forward. We're looking specifically at detention and demurrage, how it's being implemented, whether or not it's being used as a penalty in circumstances where it's very difficult for our shippers to be able to operate, where it's under the control of carriers and terminals. We're looking at whether or not in the rush to get cargo containers to Asia for importation, whether U.S. companies who are exporting have been denied service, and that would be a violation of our statutes. We have requirements for common carriage, and refusals to deal are unreasonable. And we're also looking at the availability of equipment, that is, containers and intermodal chassis. It's unusual to me that at a point where we're importing so many cargo containers, that it's seemingly not been the same situation with the manufacturer of the equipment necessary to handle this. And I would point out that this equipment is mostly all built in China, and so we're looking at what that has done to the market and the delivery and service of our economy.
If you don't mind, we can move on to some of the questions now, because that would be very interesting for the attendees. I have one
fine.
question, which is from from Project 44, who have made this event possible. According to their intel report, and they do give a lot of very valuable intel reports, the average dwell time they've seen is, due to this congestion in Port of Los Angeles and Long Beach, is sitting at 8 days, as per their intelligence report, which I will, as you can see here, they've shown that the port dwell time is sitting at around 8 days. How does this have implications on the, not only on the customers, but also on the carriers? This kind of dwell time and the demurrage and detention implications. Can you give a brief on that?
Sure. I think so. We'd heard, for instance, that dwell time at the terminal was 14 days back a few weeks ago when we're at the height of things. The problem is, for instance, if Los Angeles is the first port of debarkation from Asia, usually they'll make subsequent movements up the coast. And having problems getting into LA means that there's delay, perhaps in Oakland and the Pacific Northwest or Canadian ports. So it delays and has resulted in cancellations recently of services in other places. As they wait in queue, they just have to make a choice ultimately to return early. And so we're seeing challenges, and that plays out, Hariesh, also in different markets. So if you're a manufacturer who's anticipating a shipment that's going to come into Seattle, and it doesn't make it there because of the time spent in LA and the need to get back to Asia, we're seeing economic disruption starting in the United States as a result of this, and it builds in multiple areas.
One other question that I wanted to ask, specifically regards to the FMC, is there's been a seemingly an increase in the oversight functions and focus for the FMC. What would you consider as the main drivers for this? I mean, the FMC suddenly seems to have popped up a lot more than it has.
Yes, I would say it's really those conditions outside of the control of the shipping public, force majeure events, the Hanjin bankruptcy, for instance, recently created a lot of issues. The size of container ships is so massive now, it's becoming increasingly challenging on the shore to orchestrate intermodal services, and COVID-19 right now was a changer and perhaps economic activity. I was talking to our port director in New York, who indicated that aviation fees for his port were down 50% the past year, whereas maritime was at 100 or 100+% in charges. So there's a fundamental shift towards utilization of maritime. So those have all contributed to a need to evaluate what's going on, especially in these larger port complexes.
While the demurrage issue is understandable due to port delays or congestion or lack of cargo, some people are questioning the logic behind the interpretive rule, looking at detention as well, because in the case of detention, the container is already with the client and they have an obligation to return the empty container in time.
Well, I think that's correct. I think it actually goes both ways. And so detention and demurrage is not just there to protect the interests of the carriers to levy penalties and to ensure that in the case of demurrage, the shipper picks up cargo, but also to make sure that equipment is returned so that they can be efficient in the use of that and keep the fluidity of the market. So I think that's right. I agree. And so I always point out that this cuts both ways. Our shippers will complain when they are levied, detention and they can't bring back an intermodal chassis to our terminal. So our guidance really was intended to take advantage of the incentive principle of fluidity, and that cuts both ways.
Yeah, and I'm glad that you mentioned about it going both ways, because while there is pressure on the carriers to waive the demurrage and detention, there's also a question whether there will be a reciprocation from the ports and terminals in terms of waiving port storages, because that is beyond the control of the carriers. So is there any ruling towards that or any discussions with the ports on those that aspect?
We're looking at the issue of detention demurrage and its application right now, but it's complex because in certain contracts, the carriers have said that their own policies on detention and demurrage will cover both their marine terminal operations, and they work that out separately in terms of demurrage payments. And in other cases, both parties will levy detention and demurrage, and then other cases, the marine terminal operator will. So I've found it to be pretty complex where there's been multiple parties. So we're looking more closely at the principles surrounding the assessment itself rather than who would be doing the assessment, but it varies. So it's challenging.
Right, and here's a question from somebody anonymous. They say, we are grateful for the efforts undertaken by the FMC on the topic of demurrage and detention, equipment shortages, as well as challenges facing our exporters. How is the FMC going to measure and validate the actual availability date as defined in the guidelines? And how is the FMC going to audit these data points?
I would say I'm a little dissatisfied with the shipping public, the shippers, the carriers in this instance, and their ability to provide better transparency and notice of service. We have carriers that are providing, notice to shippers of return, the availability to bring cargo in for export, and that data is changing, and they're not really doing a great job of providing that information. So I will be asking questions to see whether we can get greater transparency information on the availability of where vessels are and when they will be functioning to unload cargo and when cargo is available for delivery. And really, this is a technology that we have in place. We just haven't harnessed it effectively, in my view, in the maritime industry. So we'll be looking at that issue, and I hope to push the industry to come up with some solutions.
And I would assume some of this is quite new as well because of the sheer volume of these complaints that have cropped up in recent times. I mean, in fact, one of the other questions, the anonymous attendee also says that they hesitate to create noise with the shipping lines because they don't want to make the situation worse. So I guess there's that fear also from some of the customers.
Yeah, and we're sort of wrestling with this. I spent a lot of time on phones and on team meetings and Zoom with the shipping public. And when I started working on shipping issues a number of years ago, there were 20 or more carriers with market share of less than 4%. Now we have 8 or 9 major carriers in the intermodal trades. So I can understand that. I think we need to look at how to protect these claims going forward if they're to levy allegations at the FMC. On the other hand, I would say that due process requirements mandate that if someone makes allegations of unfair practices or unreasonable practices, the carrier also has an opportunity to defend himself. So that's where we've had some challenges.
Naturally. And what type of because US as a market deals a lot with inland movements, as you mentioned, intermodal movements involving trucks, rail, and feeder vessels and many different options. What sort of interagency coordination do you have in terms of working with the railroad ramps? Because I believe they have their own D&D and there's no oversight there.
Yeah. So I would say these are all sort of operational requirements. The FMC has jurisdiction over international liner shipping, and it's intermodal through rates. So if it's an pure intermodal international rate, we can look at the practices of trucking, drayage trucking, and a lot of our agreements, for instance, are for the pooling of intermodal chassis and also railroads. I believe we have jurisdiction to take a look at what they're doing. There is a separate agency in the United States, the Surface Transportation Board, a sister independent agency, used to actually be the Independent Commerce Commission. They have jurisdiction over all of the pure railroad domestic movements. They have taken steps to exempt intermodal from a lot of regulatory oversight. But I do believe we have the ability to take a look at those issues. And I think we need to set up a mechanism for greater transparency between the different modes in the United States for intermodal activity. And so that's something we're looking at, whether or not we can get the industry to cooperate with to a greater extent, or furnish forums or something to allow them to work together to a greater extent.
All right. Peter Schneider from TGS Logistics has an interesting question here. He's asking, is there going to be any new accountability in a new shipping act, because the exporter is not responsible for many of these charges where they've been built for in terms of storage or chassis or other related costs? And he wants to know how we can get this cleaned up and the responsible party pay for this. Is there going to be any new accountability as part of the new shipping act or of sorts?
So I would say we've heard, rumblings that people are looking at legislative changes. It's a little bit difficult to conceive of what the proposals could be at this point, because as we spoke earlier, detention and demurrage cuts both ways. There are obligations on both parties in terms of the incentive principles that we're looking at, but conceivably it could be the subject of legislation. I've had numerous calls from members of Congress, and they've expressed concerns, in particular on the agricultural export side of the United States. We have a new trade agreement with China that's intended to promote our exports, our agricultural exports, and frankly, we haven't seen the levels that we thought we would see on that. So it's out there. I can't tell whether or not the industry, the shipping industry, shippers are consolidating on how to approach it legislatively, but it's a possibility.
You touched upon technology and its uses briefly, that you've not fully utilized or fully leveraged that yet. And is there any plans to or progress on unifying and standardizing the data? This is a question from Michael Schenk.
Yeah, there have been some activities in this area. We have, I believe, 2 or 3 agreements on file at the FMC where the industry is working together to establish digital standardization for communications. I'm supportive of those efforts. I have, in evaluating those agreements, expressed some concern because I really would like to see it be technology neutral and modal neutral, so as to expand potential utilization. So moving forward, I'm going to be pushing to ensure that we have an open architecture system that could use technology to increase transparency and to allow other modes and other participants and shippers and carriers to use the value of what we could get from technology.
All right, and another question that has come up is the worry from the market about the significant increase in the number of containers going overboard. I mean, there have been in the last 12 months there have been several ships that have gone overboard. So is there any scope of an investigation by the FMC on this, or is it something that that concerns the FMC?
It's not as much of an FMC concern because commonly our Coast Guard would evaluate whether or not they'd done proper safety with respect to stowage and that, but it does affect in a larger sense the viability of the entire market. So when one of these ships has an issue, usually they have to pull it out, and it's probably a ship that has an agreement in effect, so multiple players are using it, multiple shippers are affected. So from the safety perspective, no, it's not our jurisdiction. That's the jurisdiction of the U.S. Coast Guard. But from a macro market perspective, yes, it does concern us.
All right, and there's also the question from Mr. Fossey about that there's about 15,000 TEU plus ships are putting some pressure on the port and landside infrastructure. And are these congestion problems and the being experienced at the port not related to the size of the vessels and the lack of investment on the port side, or is it more to the ocean carriers' pricing strategies? Because congestion can't be because of that.
Yeah, well, there's some pressure put on because of the carrier's intention to utilize larger vessels. Clearly, we're spending a lot of money in the United States. We don't have a centralized port authority that manages that. Actually, constitutionally, we protect the right of each state to operate a port, and so there's a lot of competition, which is good. But we've seen, for example, in Houston, a very large port in the Gulf Coast has taken steps in the state legislature to restrict Neo-Panamax vessels from transiting its channel, and it's a concern on the ability. It should be a concern for every port in the U.S. Gulf Coast who's investing, hundreds of millions of dollars in deeper water and in equipment for handling the cargo. So it's creating challenges. It is putting costs on our port cities and our states to accommodate these vessels, and it's putting challenges on how we handle it. On the other hand, the carrier will tell me that they spend 20 to 30% less for each box if it's a large vessel. So there's some value to exporters, to importers, retailers in that service. And in general, containerized shipping is very cost competitive for the value of the goods that are being provided to the public.
Just taking you back to your earlier information about the functions of FMC, you mentioned that one of the functions is the authority to take action on foreign national unfair shipping practices. Can you elaborate a little more on what those unfair practices that you're seeing currently?
Well, it's really that we're looking at the practices of foreign governments, not foreign nationals, but foreign national laws, where a foreign government enacts a law or regulation that is different from what we would do. We're not hypocritical on this. You have to be doing something that affects the public in a way that we don't do. And we can evaluate those. People can petition who feel that they've been aggrieved by virtue of a potential national. And there's got to be some level of national control in the policy that we look at. Examples in the past are probably the easiest one because we only have one pending now. But in Japan, in the late 1990s, there were laws, restrictions on who could open trucking companies for intermodal trucking, and it required majority control of a Japanese national company. And so the carriers complained that they were forced to give their cargo to their competitor Japanese lines when they exchanged intermodal service, and they petitioned, and ultimately the issue was resolved. I think the Japanese government enacted liberalization, so the whole world sort of benefited from allowing the carriers to establish their own operations, intermodal operations. So that's an example of how it worked in that case. Right now, we have a case pending where we're evaluating ballast water requirements in the Great Lakes. Great Lakes are internal lakes in the United States, and we have a fleet of vessels, very large Great Lakes vessels that go back and forth, mostly in the United States, but occasionally to Canada. They're so big that they can't get out of the Great Lakes. And in fact, every year when the lakes freeze over, they put them up in dry dock for 2 or 3 months, and then they resume service. Canada is assessing putting international ballast water requirements for treatment of ballast water. I think the petition that was presented to us on behalf of the Great Lakes carriers was, we don't go into international waters. We're in the Great Lakes, and the ecosystem is the same on both sides of the lake. We feel, and the Canadians have not implemented any regulations, final regulations, but that would be an example that we could look at and see whether or not these were in fact barriers creating unfair conditions in the foreign trade.
Speaking about national control, there's a question from George Kokanowski. I think I pronounced it correctly, I hope. Do you see a time when Jones Act carriers will become international players?
So I think we're seeing a little bit of that with respect to Matson Navigation. Matson is a smaller player in the Pacific, but they've been very nimble. They own terminals along the West Coast. They control their own intermodal assets. And so they've been successful. Traditionally, they provide service to Hawaii and the mainland, to Hawaii, and also to Alaska, and then some of the Micronesian islands, but also to China and a round trip. And they've expanded their services quite dramatically during the pandemic. And in fact, I would contend that in some respects they're taking advantage of control of their own terminals and their equipment to provide express services and guarantees. So I don't think they're at the level right now of our international carriers, but I would think that that would be the one that would be the closest to doing that. And we have other regional carriers. Crawley, for instance, Maritime is a major player in the north and this hemispheric trade in the United and in our hemisphere. So, but those would be the two closest to and really you're 8 or 9 major players right now. So it's been a severe consolidation in the industry.
Yeah. And do you have a number or a sense of economic impact this excessive demurrage and detention is causing to the trade?
We don't. It's a good question. It's really a assessment that's tacked on to the payment of freight, and so we don't require reporting on that. We have reporting on the contracts, but not the actual freight bill per se. So we don't really have an assessment, and a lot of the information that we get is anecdotal. We urge shippers to provide us information on it, and so, but we don't know how large the bill is.
Right. There's a question from Laurent Richard, who's asking how the FMC is controlling the cost and competition between carriers as they seem to be facing a weird alignment on rates. For example, one of the lines implements a imbalance surcharge, and all carriers are following that with the same amount. How is FMC controlling these?
The FMC has authority to evaluate. Actually, the 98% of our trade is carried by one of the 3 alliances that exist, and we evaluated all of those alliances when they came into effect. And we have what's called continuing monitoring agreements. Those are agreements where we get reports quarterly, but also monthly about the pricing practices of carriers. So we get information about the prices the revenues that they earn per box, per container, and in addition, we have access to the contracts, shipping contracts, and people are required to file their tariffs publicly, and so we know where that information is. So we have a team of people looking at the rate issue. But I will tell you, it's very complex because we have contracts, and I believe I actually believe that they're really not contracts because they don't have binding commitments to do anything, but they have a rate structure that is what your named rate would be and what your spot rate would be, but there's no mechanism to enforce when you go at a higher or in some cases lower rate on the spot market and when you go at your negotiated rate, your name rate. So it's really challenging. We also look at the different markets, the intel providers who also do assessments in a variety of mechanisms. So we have information on it. We've had a number of internal hearings to look at the rate issues. And when the challenge I think that we've had in the market is for 8 of the 10 previous years, carriers have lost money in the major trade lanes. And so there's a built up reservoir of loss that exists on one hand, and now quite drastic increases, doubling or tripling of rates, and a combination of doubling or tripling of rates and failure of service because of congestion issues. I'm not blaming on the carriers on all of these, but that confluence is difficult to reconcile.
Yeah, I mean, as you mentioned earlier, also it is quite complex, the goings on within United States, and also trying to match with what the rest of the world is doing, which also raises a question. although there's this monitoring and oversight on the shipping lines, does the FMC also look at the practices by the terminals as part of your managing of the port operations? If the terminals are doing, I mean, having some sort of collusion or any of those kind
So
of things?
yes, we do. We have marine terminal tariffs are required to be published and updated, and they have to comply with the terms of those terminals. They are authorized as our carriers to enter into agreements with other parties, including non carriers. They can be companies that do intelligence or technology or such, but we do have agreements on file with the MTOs, and they become quite contentious and at times in the past on whether or not they're anti-competitive, whether or not we should allow them to go into effect. And so it does periodically come as an issue, but we generally have authority over marine terminal operations and carriers very clearly, and then intermodal jurisdiction to the extent that it's connected to practices of international intermodal liner shipping.
What is the situation of the chassis currently? The shortages, has it relaxed? Has it improved, or is it still the same?
It's gotten a little bit better. I give credit to the chassis provider companies. In the United States, we're a little bit unique in that truck drivers get their chassis at the port, and it's in control. It used to be in the control of the carriers themselves. They would stack them up at the terminals, which they also owned at the time. But the market has gone completely separate, where you have a situation where carriers are separate from marine terminal operators, which are separate from equipment providers, chassis equipment providers, and we've seen some challenges. But we talked early on in the process. I talked to all of the intermodal chassis providers, and they were trying the best that they could to get equipment to those large port complexes that were getting congestion. I heard today that the issue through the terminals was better, but that we were really having a lot of problems getting equipment over to the rail yards, and they weren't. The rail cars were not available for the movement of the intermodal equipment into the interior. So we're seeing a lot of delay in that particular area. So it's shifted a little bit. So that's good news. I continue to be concerned again. The market for intermodal chassis is almost in the world is 85% done in China. So concerned about both container manufacture, which is almost uniquely done in China, and intermodal. So it's something that we should all think about.
Yeah, that is certainly good news indeed, especially now with all the congestion and the boom in trade. There's a question from Kuljit Anand. She wants to know, how are the peak season surcharges being controlled by the FMC? Because previously it used to be once a year. Now it just gives a once a month heads up, and then boom, there's a peak season surcharge.
We have periodic reviews of the rates, and it's the same way we treat any rate increases. And like I say, there's a lot of complexity because some people have contracts, some people ship through NVOCCs, and some exclusively on the spot market, and then you have BAFs that are imposed by terms of a tariff, and you have peak season.
There are many different alphabets.
Many different alphabets, and so we try the best that we can. We have some people that are just evaluating, looking at the data. I have my guy at the FMC that I call to try to find out what's going on with the rates, and they fluctuate. And I'd say the market has been very favorable in favor of the shippers for a long period of time, and in my view, it may be changing, and may be changing with permanency.
Well, Commissioner Bentzel, I think it is time for us to thank you. And it has been a really interesting conversation, and I'm sure many of the attendees have also had a great value from this. Unfortunately, we were not able to cover all the questions. There were a lot more. And for those who have whose questions have not been attended to, you can send it to the organizer of this, Priyanka at pesti.io, and we will try and catch up with the commissioner for those questions and see how we can respond to that. But Commissioner Bentzel, we must do this quite often. It seems, because there's a lot of interest in especially your work and the FMC's work. And we thank you for your time today on behalf of Project 44 and Charlie Pesti. And thank you once again for giving us the privilege to speak to you. And see you soon sometime.
I'd be pleased to do it again. Enjoyed our conversations. It's always nice because the shipping community, maritime people do such critical, essential work, and they really care about the industry. So it's always nice to talk to the public.
Thank you. Thank you. And thank you to everybody for attending.